Welcome to the first installment of my course on substantive Canadian criminal law. In this episode, we will talk about the sources of Canadian criminal law, that is, where it comes from. Our focus will be on the respective roles of the courts and Parliament in making the law. We will discuss the extent to which there is a role for the common law, as well as to judge-made law interpreting statutes, and what the difference is between them. We'll talk about why there is resistance to the idea of common law crimes in Canada. We'll talk about why it is that common law defenses may not raise similar concerns. And along the way, we will talk about aspects of the Supreme Court of Canada's rulings in Frey versus Federick, the Queen versus Jarvis, and the Queen versus Jobidun. Now, it bears saying that this will be an unusually abstract lecture at times, but we cannot sensibly grapple with the statutes and cases that we'll read later on without having some sense right at the outset on the respective roles of the courts and Parliament. And this does get us into the weeds a little bit. So, let's get started. Insofar as our focus is on true crimes rather than regulatory offenses, we can say that there are four principal sources of the criminal law. First and foremost, statute law. Chiefly, though not exclusively, the criminal code. Second, judge-made law issued in the course of interpreting statutory provisions. Third, common law rulings creating or modifying certain defenses, particularly excusatory and institutional defenses. And finally, common law rulings pertaining to the offense of criminal contempt. Now, this last category is quite exceptional. It is the one and only common law offense remaining in Canada. It persists only because Parliament expressly allowed for the common law to play a role in the ongoing development of this offense. Indeed, it's so exceptional that when Elizabeth May was convicted of criminal contempt in 2018, she claimed that she wasn't really convicted of a criminal offense at all, since these don't exist at common law. Now, she was wrong. Criminal contempt is still a crime. But she's also right to think that there's something extraordinary about a criminal offense that can be modified and altered by the courts at common law. And because it is so extraordinary, we will spend vanishingly little time on it. But I would just draw your attention right now to its existence. On the occasions when we turn away from true crimes and move towards regulatory offenses, there is an additional dimension, an additional wrinkle. And that is, whereas in the context of true crimes, only the federal Parliament can create those, the provinces play a conspicuous and dominant role in the context of regulatory offenses. So, given that we're going to spend time on regulatory offenses only much later in the term, and given that we won't actually get deep into criminal defenses until much later in the term, and given that we won't be talking about the common law offense of criminal contempt much at all, really we can say that for much of the first half to 3/4 of this course, our focus is going to be almost exclusively on federal statutes, and notably the criminal code, and on judge-made law in the sense of cases which set out to interpret a phrase or word or provision in the criminal code. So, a disclaimer at this point. What I'm about to say about the distinction between judge-made law and the common law might well be justly accused of having an element of caricature to it. But for our purposes, it's enough that we draw a sort of rough and ready line between the two. And that's what all I want to do for now. So how does the common law work? Well, now the gut instinct of many students, lawyers, legal academics will be to point to the doctrine of precedent and treat the doctrine of precedent as the defining aspect of the common law. Now, that's not necessarily wrong in some respects. Certainly the way that the common law has operated over the last couple of hundred years has emphasized the doctrine of precedent. It has emphasized what first-year law students will have only just recently come to have learned to call stare decisis. But of course, the common law is not just a couple of hundred years old. The common law is about 800 years old and is far older than any workable doctrine of precedent. The key thing to keep in mind about the common law is how it has come to develop. And the really sort of crucial point to keep in mind is that the common law develops in response to actual disputes that have come before the court. And in principle, there may be no settled law governing that dispute prior to the court looking at it and deciding for itself that no, under these circumstances, the plaintiff is or is not entitled to this remedy. So that's the key point to keep in mind, right? That the common law is reactive. The law emerges often only in response to the disputes that are brought before the court. So if we imagine, as it were, in a legal state of nature, there is no law governing this case, no pre-existing law, I should say. So A makes an allegation against B, and it will now fall to the court to decide whether, assuming that those allegations are made out, A ought to have an actionable claim against B for this remedy. And we'll say, just to make things easy, damages. So this is inherently ex post facto or reactive reasoning being employed by the court. And not only is the court deciding what A ought to be entitled to in light of the allegations, assuming those allegations are ultimately made out, but the court will also be guided by what remedies it regards itself as competent and qualified to order. Now you can say, okay, well, that all sounds great. That makes sense of the idea that in a legal state of nature, the courts are acting in a reactive fashion. But what if there's a precedent? Well, now we're not in a legal state of nature anymore, and surely now it's not quite so reactive. Well, hold your horses, because of course, on any plausible theory of precedent, the courts are entitled to revisit the legal propositions that they have set out in previous cases. They may overrule themselves entirely, say, no, actually, we said this back at that earlier case, but we now have concluded that that is a bad legal proposition, so we are just sweeping that away. They may do something far more modest. They may say, well, in that earlier case, we said that this legal proposition would apply to X, Y, and Z circumstances. Well, now we're also going to say they operate in Q circumstances. They may say, well, we're going to actually roll back that legal proposition. And even though we said that that proposition would apply in X, Y, and Z, now we've just concluded it'll only apply in X and Y. And what is happening here when the court does this? The court is reacting to the new set of circumstances, the new set of facts, you might say, the new set of allegations that have been presented to it in the instant case. The court has said to itself, okay, we might otherwise have proceeded on the basis that this legal proposition that we earlier articulated, that would govern all cases like that earlier case. But now we have in front of us a case that, as it were, we simply cannot countenance, recognizing that on the cause of action here. So after the fact, the legal proposition recognized in the earlier case is being made to bend in response to newly recognized circumstances. And it may well be that the parties to this dispute had both come to court assuming that that earlier articulated legal proposition would apply to them. But the court says, after the fact, no. Based on the particular facts that are now in front of us, we are revising the law. Again, in a more expansive way or in a more constrictive way. Now, as all this suggests, within the framework of the common law, we see a quite aggressive role for the courts in deciding what the law is. And this will be quite nakedly based on the court's own moral and policy preferences, moral views and policy preferences or sensibilities. And what's more, and this is sort of tied into the point that I just made about this more aggressive role. Why do the courts feel comfortable taking this view, taking this approach, imposing their own moral values and policy preferences on litigants, again, after the fact? Well, it has a lot to do, of course, with, again, what the courts think it is within their power to order by way of remedy. The very fact, it's not an accident that within the sphere of the common law, we are chiefly talking about whether or not damages are to be awarded. This is a relatively non-intrusive remedy. We're not talking here about, for example, deprivations of liberty ordered against the defendant. In the context of private law remedies, we know that certain remedies are regarded as with particular suspicion. Remedies like, for example, mandamus. The paradigmatic remedy in the common law is damages, which will cost the defendant some money, but is not intrusive in the same way as other potential remedies are. So what jumps out at us about that paradigmatic common law case that I was just describing is that there's a sense in which we start with the factual allegations and then move to the law. We start with the allegations and then determine whether or not there is a cause of action or should lie a cause of action, and whether or not we, the court, are entitled to award the sought-after remedy. We start with the facts and we move to the law. The situation is quite different where there is a statute in play. Suppose we have a statute that states, in no uncertain terms, that in circumstances X and Y, a court must provide this remedy or this sanction. So if we imagine a statute that says where so-and-so engages in this conduct under these circumstances, this remedy shall be owed to the plaintiff, or this sanction shall be imposed upon the defendant. Well, now, in a case like that, suddenly there's now no question as to whether or not a cause of action in principle exists, or whether or not a court is entitled to deliver the sought-after remedy. The statute settles that. The only real question now for the court is when are X and Y made out? You know, the statute says that the defendant must engage in conduct X under circumstance Y. Okay, well, what does X and Y entail? And under what circumstances can we say those conditions are met? And what that effectively means is that the court's entire attention at the front end of the case is on the meaning of X and Y. What conduct and what circumstances are set out in the statute? What does it cover? And only once we know what that statutory provision encompasses does it make sense to turn to the specific factual allegations in issue and determine whether or not the alleged conduct falls within the ambit of the statutory provision in dispute. Now, importantly, as a court goes about interpreting a statutory provision, it's not worried so much about the particular facts in issue. The meaning of a statute doesn't change depending on who the parties are in a given case. A statute is, by its very nature, designed to cover a wide range of circumstances. And we're not going to learn anything about what the statute means by focusing on the particular parties who are before the court in the instant case. Put another way, we would wind up in a somewhat circular situation, wouldn't we, if we purported to interpret the statutory provision in issue by looking to the particular facts in dispute between the parties. After all, we are interpreting the statute in the first place in order to determine whether or not the court, in a sense, has jurisdiction to impose the sought after remedy or sanction upon the defendant. Now, it wouldn't do any good to do that where there would be no sense in doing that. If we were then to say, oh, well, I think that this defendant should have this sanction imposed upon him, so I'm going to superimpose my view upon the statute. In that case, what work is the statute doing? In the end, we would be in the same situation as we are in a common law case, where the judge simply looks at the allegations, decides for him or herself, all right, does a cause of action lie here in my view, based on my own moral and political sensibilities, and I think a remedy should be owed here. We'd be in the same situation. So in order for the statute to do its own work, in a sense, we have to bracket off the particular facts in front of us, ignore those. We have to set those aside and instead simply focus on the abstract meaning of the statutory provision in question. And that fundamentally is what courts do in criminal cases as they determine what the scope is of this or that criminal offense in particular. They start with what is the meaning of the statutory provision here, and only once they've determined that do they then move to the particular allegations against the defendant, the specific defendant before the court. We start with the law and we move to the facts. And it's in that critical, though admittedly subtle and messy way, that a criminal case is fundamentally different from a common law case. It's in the direction of travel and in the relationship between the factual findings, the factual determinations, the factual questions, and the legal questions and legal determinations. Now, of course, that whole account of what distinguishes, say, our paradigmatic common law case from our paradigmatic statute-driven case might be thought to beg some questions, or what, at least a couple. In particular, one might be inclined to ask, okay, you've suggested that it would be inappropriate for a court to simply impose his or her own values or philosophies upon the statutory provision in issue. Well, why? Why shouldn't we simply proceed on the basis that, statute or not, all cases really are more or less a variation on a common law theme, and that in effect, ex post facto reasoning is just the order of the day and is perfectly fine. Why not reason in that way? And there's a couple of ways to come at this. The first is to point out that, particularly in the criminal context, where the remedy or sanction involves deprivations of liberty, or at least tends to involve deprivations of liberty, we have deep concerns about courts engaging in this sort of ex post facto reasoning. You'll recall that in my discussion of the paradigmatic common law case, that really what tends to be in dispute is whether or not damages should be awarded. Now, damages may indeed impose some burdens, perhaps significant burdens, upon a losing defendant. But they don't raise the same sort of liberty concerns that a criminal case involves, or indeed any case in which the liberty of the defendant is at stake. And in a circumstance like this, we may well be inclined to think that here in particular, people need fair warning in advance of engaging in whatever conduct is said to have triggered the sought after remedy, is said to justify the sought after remedy. That folks need to have fair warning that if they're going to do this, that they may find their lives irretrievably disrupted. Now, I've just suggested that one of the important reasons why we rely on statutes in criminal cases is that we want to ensure that defendants have what we often describe as fair warning, that the conduct they're embarking upon is, or at least may, trigger a particular sanction, and indeed a serious sanction, a deprivation of liberty. And we think this matters because we think that citizens should be entitled to be able to make plans, and it is only by knowing in advance whether or not they are subject to having their liberty deprived that people can live meaningful, fruitful lives. But there are a number of cases, one might even suggest many cases, in which this plea for more notice, as it were, more warning, really does seem to ring a little bit hollow. There are quite a number of cases where we might well ask, did you, the defendant, really need specific warning that this course of action was wrongful before you embarked upon it? Did you really have not a glimmer of even the slightest inkling that if you engaged in this course of action, that you might face serious consequences, possibly including a deprivation of liberty? And just as one often cited example, we might look to, first, Sedley's case. Now, I, of course, am far too bashful to describe in my own words what it is that Sir Charles Sedley did that landed him in such hot water. Conveniently, though, I can look to Samuel Pepys' diary, where he describes the events at Oxford Cates. Mr. Batten telling us of a late trial of Sir Charles Sedley the other day, before my Lord Chief Justice Foster and the whole bench, for his debauchery a little while since at Oxford Cates, coming an open day into the balcony, and showed his nakedness, and abusing of Scripture, and as it were from thence preaching a mountebank sermon from the pulpit, saying that there he had to sell a powder as should make all the women in town run after him, 1,000 people standing underneath to see and hear him. And that being done, he took a glass of wine and washed his prick in it, and then drank it off, and then took another and drank the king's health. Seems my lord and the rest of the judges did all of them round give him a most high reproof. My Lord Chief Justice saying that it was for him and such wicked wretches as he was, that God's anger and judgments hung over us. It's said they have bound him to his good behavior, there being no law against him for it, in £5,000. Now, to modern Canadian ears, what stands out from Samuel Pepys' account, aside from Sir Charles Sedley's behavior at Oxford Cates, is that last line, there being no law against him for it. If there was no law at the time that he went to Oxford Cates and shewed his nakedness, among other things, then on what basis could the court punish him for what he'd done? Well, the answer is that the court regarded itself not simply as an enforcer of statutory law, not merely, as it were, a passive enforcer of criminal offenses that had already been recognized by the legislature. It regarded itself as the custos morum, or keeper of the morals, and to that extent regarded itself as free to recognize after the fact that the conduct engaged in by Sir Charles Sedley, even if it was not recognized as a crime at the time, could now so be recognized. Again, after the fact. Now, of course, one complaint we might have about that is that, well, how is Sir Charles Sedley to know that he couldn't engage in this conduct if it hadn't been recognized as a crime to that point? But at the same time, I'm sure I'm not the only one who has a little voice inside their head that says, really? You had no idea when you went onto that balcony and whipped out, as it were, little Charles Sedley and threw down bottles of urine into the crowd below? You had no idea that you might suffer some sort of punishment later on for this behavior? Not a glimmer. Now, as we've seen, many of the arguments against common law offenses really trade on ideas of certainty and fair notice. If you're going to punish me for embarking on a course of action, it's incumbent upon you, the state, to tell me in advance that it is wrongful for me to engage in this course of action and that I face sanctions if I go ahead and do it anyway. Now, how much force do these sorts of arguments have? Well, the answer is, it depends on the kind of conduct we're talking about. Some courses of action are, we might say, malum in se. They are wrongful in and of themselves, intrinsically wrongful. Their wrongfulness doesn't depend on whether or not the state happens to make it wrong. They just are. Now, the archetypal examples of malum in se conduct are course of action like murder, or assault, or theft. Here, the idea that I didn't know I couldn't do this because you didn't publish a statute saying expressly that I couldn't really starts to ring a bit hollow. And so we may be inclined to think that where the conduct that we're talking about is malum in se, the arguments against common law offenses that trade on ideas of certainty and fair notice lose at least a bunch of their force. By contrast, when we're talking about courses of action that are malum prohibitum, these sorts of arguments get a fair bit more traction. What am I talking about when I talk about malum prohibitum? I'm talking about courses of action that may be permissible in and of themselves, and that are only wrongful simply because the state or the legislature has chosen to make this conduct criminal. Now, what sorts of conduct do I have in mind? I have in mind, regulatory offenses, making it an offense to tear tags off of mattresses, or offenses making it a crime to drive on the left-hand side of the road but not the right. Now, there's nothing intrinsically immoral about tearing the tag off your mattress. And there's nothing intrinsically immoral about driving on the left-hand side of the road rather than the right. Often these offenses are the legislature engaging in line drawing exercises, or simply making a call just for the sake of having an enforceable administrative scheme of some sort. But the point is that when we're dealing with this sort of conduct, which is not malum in se, it becomes much more credible for someone to argue, I didn't know that I couldn't do this, and indeed didn't have even an inkling that it might be impermissible. And here arguments of certainty and fair notice are at their high watermark. And it goes to questions of parliamentary sovereignty and the separation of powers. Over and above fair notice concerns about courts creating criminal offenses ex post facto, we also have a strong intuition that if anyone is going to create a criminal offense, it really ought to be our elected representatives in Parliament and not unelected judges. Why? Because declaring a course of action to be criminal is about as profound an exercise of power as one can imagine. Based on what it is that Parliament says is now criminal, it may be that whole social practices and institutions are transformed, that relationships are transformed, that ways of life, which hitherto were permissible, perhaps even celebrated, suddenly become off limits. If anyone is going to exert this sort of power over how Canadians live their lives and interact with one another, we intuit that it should be Parliament. So that, if nothing else, having created a criminal offense, we, the voter, get to decide, get to pass judgment on them in turn. They are accountable to us for the decisions that they make that affect our lives in such profound ways. And of course, this doesn't even speak to the fact that having created a criminal offense, there may be many folks out there who are now subject to grave deprivations of liberty. One night in March 1947, Stephen Federick was awakened by his wife. His mother was yelling out, "Man at window." Federick rushed outside and saw someone leaving his property. That man was Bernard Frey. Federick caught up to Frey and accused him of peering into his mother's window. Frey had no answer other than, "What do you want?" Federick led him back to the house. His mother identified Frey as the man she had seen, and they called the police. Frey was subsequently charged with acting in such a manner likely to cause a breach of the peace. Now, Frey was ultimately acquitted. The British Columbia Court of Appeal decided that the evidence was not strong enough to warrant a conviction. And one would have thought that the whole matter would end there. But Frey, in a move that we can only describe as nervy, decided he wanted to go even further. He sued Frederick and the constables for detaining him. He argued that he was, in effect, the victim of false imprisonment. And the whole crux of Frey's claim was that even if there had been compelling evidence that he'd been, as it were, a peeping Tom, there still would have been no legal basis for arresting him, for the simple reason that it wasn't a criminal offense to engage in that conduct. Now, for their part, in their defense, Frederick and the officers argued that, okay, even if it's true that Frey's conduct was not criminal at the time he engaged in it, it was open to the courts to make it criminal after the fact. In other words, they insisted that it was open to the courts to create new criminal offenses at common law. And the Supreme Court flatly said no. Accepting that argument, the majority said, would introduce, quote, great uncertainty into the administration of the criminal law, leaving it to the judicial officer trying any particular charge to decide that the acts proved constituted a crime or otherwise, not by reference to any defined standard, but according to his individual view. In other words, the court relied heavily on ideas of fair notice, on the importance of fair notice. And going forward, Justice Cartwright, writing for the Supreme Court, insisted that any new crimes would need to be created by Parliament. They could not be created at common law. Following the Supreme Court of Canada's decision in Frey versus Frederick, Parliament undertook an extensive revision of the criminal code. And one result of that is Section 9, which states definitively there are to be no common law offenses, with one exception. If you go right to the bottom of Section 9, it says, nothing in this section affects the power, jurisdiction, or authority that a court judge, justice, or provincial court judge had immediately before April 1st, 1955, to impose punishment for contempt of court. So, notwithstanding the fact that there are otherwise no offenses at common law, the common law offense of contempt of court remains, and it is the one common law offense that survives. So, following Frey versus Frederick and the 1955 revisions to the criminal code, we are left with a situation in which there are no longer any common law criminal offenses, and with the exception of criminal contempt, which is the sole survivor. But that's not the last word on the relationship between the criminal law and the common law. Because let's take a quick look now at Section 8 sub 3 of the Criminal Code. This states that, quote, every rule and principle of the common law that renders any circumstance a justification or excuse for an act or a defense to a charge continues in force and applies in respective proceedings for an offense under this act or any other act of Parliament, except insofar as they are altered by or are inconsistent with this act or any other act of Parliament. So what does this provision essentially say? it says that the courts have retained the power to create or alter common law defenses, except where doing so would be inconsistent with either the code or with some other federal statute. Now, why would Parliament treat common law defenses in a way that is distinct from the way it treats common law offenses? As we've seen, Parliament has made it clear the courts can no longer create new offenses at common law. Yet Section 8 sub 3 allows for courts to create new common law defenses or to alter existing common law defenses. Why do that? Why take that different approach? And the answer in large part goes to, again, the way in which arguments from fair notice work. Why treat common law defenses differently from common law offenses? We've seen that Section 9 abrogates common law offenses and makes it impossible, at least in principle, for the courts to create new common law offenses. Why not take the same approach with respect to common law defenses? Why not simply say, judges, you can no longer recognize new defenses at common law. You have to live with the defenses that we in Parliament recognize. Well, there's a couple of answers to that. Recall some of our reasons for not recognizing common law offenses. We might look to, first, arguments of fair notice or legality. We're concerned with respect to common law offenses that citizens will be surprised, as it were, that they will be trying to make plans for their lives, they will be relying on statutory guidance, suggesting that they're entitled to go about certain courses of action. And then what happens? Well, if we recognize common law offenses, well, then what will happen is that they will, in good faith, engage in these courses of action, and then a judge will surprise them after, as it were, and say, oh, no, notwithstanding the fact that you may have thought that this course of action was available to you, I'm going to throw a thunderbolt and say that actually it was not, and I'm going to punish you. We have an intuition that this is deeply problematic. How are people supposed to make plans in their lives if they may, in good faith, embark upon a course of action only to be told later, actually, no, you weren't allowed to do this, and I'm going to punish you now. I'm going to throw you in jail. Does that same consideration, does that same concern arise when we're talking about common law defenses? Well, not exactly. Because when you think about a common law defense and courts creating new defenses after the fact, what's the worst that happens? The worst that happens, we might think, is that I embarked upon a course of action, and in principle, I knew it was criminal. But after the fact, a court tells me, actually, even though it was contrary to a criminal offense, we conclude, again, after the fact, that you have a defense available to you. Now, I'm still surprised, but it's a happy surprise now. Now I'm in a situation where, having thought that I would face this criminal punishment, I get a windfall. Now Whereas before I might have thought, oh dear, I'm going to go to jail for embarking upon this course of action. I do it anyway, and I'm caught, and I'm tried. But surprise, I now get to go free. Our intuition is broadly that this is not a problematic form of surprise. And so at least that, to the extent that fair notice concerns underpin the prohibition on common law offenses, that concern doesn't lead to the conclusion that common law defenses should similarly be taken off the table. So I've spent a bunch of time talking about the distinction between the common law and judge-made law. But what really turns on that distinction in the end? I've highlighted the problems that arise in the context of common law offenses, potential issues of uncertainty, fair notice, and separation of powers. But to what extent can these same problems, or broadly analogous problems, arise in the context of judge-made law generally? When courts interpret statutory provisions for the first time, we might at least sometimes think that some or all of these problems can and do still arise. There may be enough ambiguity in the text that reasonable people can disagree about what it means, and therefore have less than optimal certainty about what they can and can't do until the court authoritatively settles the matter. Likewise, there may be, at least to the cautious individual, some notice that certain acts at least could be treated as criminal, but far from perfect notice. And even though the interpreting court is ostensibly following the lead of Parliament, its interpretation may be so open-ended that it effectively gives the courts almost free rein in future cases to do what they want anyway. To illustrate this point, let's consider the relatively recent decision of the Supreme Court of Canada in Jarvis. Now, the facts in Jarvis are pretty straightforward. A high school teacher was found to have used a camera pen to video record the chest and cleavage of female students and one female teacher. The central issue here was whether or not this constituted voyeurism within the meaning of section 162 sub 1 sub c of the criminal code. So here is that provision in the code. And you'll note that it says, everyone commits an offense who surreptitiously observes, including by mechanical or electronic means, or makes a visual recording of a person who is in circumstances that give rise to a reasonable expectation of privacy, if, and we go down to sub C, the observation or recording is done for a sexual purpose. Now, the core question in this case is when we have, quote, circumstances that give rise to a reasonable expectation of privacy. And we had in this case, as we will see in many other cases that we look at this year, two competing interpretations offered by, respectively, the defendant and the Crown. The defendant argued that we should apply a relatively, we might say, closed test when determining or when asking whether someone has a reasonable expectation of privacy. And in particular, the defendant took the view that in determining whether we are in circumstances that give rise to a reasonable expectation of privacy, what should be, if not quite dispositive, at least quite weighty, is the location. In particular, whether we are dealing with a, what we might describe as a public location as opposed to a narrowly private location. And this would be quite significant for the defendant, because on the facts in this case, the recordings were being done in what we might describe as broadly public places, the hallways of a high school. So a place where many people can see the complainant, and if that's the appropriate interpretation, that we should give special weight or indeed dispositive weight to location, well then, on that view, the defendant is almost certainly not guilty of this offense. Now, the Crown, for its part, took a quite different view. The Crown took the view that a more open-ended, contextualized test should be used for determining whether the complainant is in circumstances that give rise to a reasonable expectation of privacy. And on this sort of more contextualized, open-ended approach, the mere fact that one is in a public location does not necessarily decide the question of whether or not one nonetheless has a reasonable expectation of privacy in some sense. And so the effect of this sort of more contextualized reading would be at least to make it more likely that the defendant falls afoul of section 162 sub 1 sub c. Now, importantly, in deciding which interpretation to prefer of section 162 sub 1, what the Supreme Court was ostensibly not doing was simply making a straightforward policy determination. Its job was not simply to decide when, in its view, it ought to be a crime to observe or record others for a sexual purpose, but instead to decide when, according to Parliament, it already was a criminal offense to do so. And as we'll see, the court's going to look to a range of considerations when interpreting the text of this statutory provision or other statutory provisions. But suffice to say for now, for our purposes right now, it isn't necessarily obvious which interpretation is the proper one, which interpretation should prevail, the defendant's or the Crown's. And although we'll talk a little bit more when we turn to statutory interpretation about what some of the bases for ambiguity here are, I'll just quickly set out a couple of reasons to think that it's not obvious which interpretation is the correct one. First, the ordinary meaning of that phrase, reasonable expectation of privacy, is not clear. Reasonable people can disagree about when one has a reasonable expectation of privacy. Furthermore, people can disagree about what the precise wrong was that Parliament intended to target when it created the offense of voyeurism in the first place. And here, and again, we'll talk more about this in subsequent lectures, but keep in mind that our concern here is not what Parliament might wish it had criminalized now, but what Parliament intended to criminalize at the time it enacted the offense of voyeurism. And furthermore, we're concerned not with the intentions of specific parliamentarians, specific members of Parliament. We're not concerned particularly with the views of the Prime Minister or the Minister of Justice. We're concerned with the intentions of Parliament as a corporate entity. And again, this can make it tricky to determine what it actually was meaning to target at the time. Indeed, if we take a step back, consider that at the Ontario Court of Appeal level, the Ontario Court of Appeal, of course, split on what the appropriate interpretation was of section 162 sub 1. And moreover, of course, as we'll see, the Supreme Court split on this question. So it's hardly hypothetical that reasonable people could disagree about the appropriate interpretation to give of that phrase, circumstances that give rise to a reasonable expectation of privacy. We have disagreements within the four walls of the decision itself. And of course, these are senior judges who obviously know the canons of statutory interpretation, and they still can't agree. And of course, that in itself does not, in the end, mean that we lack certainty or fair notice in principle. We do have that, but only to an extent. It's an imperfect certainty, an imperfect notice. And it's important to keep that in mind, that the mere fact that we have disagreements, the mere fact that we have ambiguity in criminal offenses, doesn't mean that somehow we've just automatically failed to achieve any sort of certainty at all, or that the notice that people have about what's a crime and what isn't fair. It's just not perfect. And just to add a little bit further embellishment to this point, let's imagine that Mr. Jarvis had been uniquely careful before he decided to bring his camera pen to the high school. Let's imagine that he actually did what many criminals do not do, which is consult a lawyer first. And so Mr. Jarvis goes into the lawyer's office and says, look, I'm thinking about doing this, but I'd like to know first whether or not in doing so, I'm going to run afoul of section 162 sub 1 sub c of the criminal code and get punished for voyeurism. And so I'm coming to you, the lawyer, to tell me. Now, what's the lawyer going to say? The lawyer is going to say, at least prior to Jarvis, well, I've looked at the various canons of interpretation, and the best that I can say is, depending on how an appellate court reads that phrase, reasonable expectation of privacy, you may or may not be committing the offense of voyeurism if you do this. And of course, Mr. Jarvis in that case might throw up his hands and say, well, what good does that do me? That doesn't provide me with certainty. That doesn't provide me with notice. But the lawyer will respond in turn, well, it doesn't give you perfect certainty or perfect notice, but it does give you at least some grounds for concern. It tells you that if you decide to proceed, you will be walking on thin ice, because it is at least a reasonable interpretation of this provision that, yes, if you bring your camera pen into the high school and use it to record the cleavage of students or teachers, that you will be on the wrong side of the law. And importantly, that is all the notice that traditionally we think you're entitled to. Now, we'll be speaking a little bit further about issues of vagueness in the next lecture. But for now, it's enough to observe that the Supreme Court regards this sort of imperfect notice as constitutionally unproblematic. Ultimately, a majority of the Supreme Court found that Mr. Jarvis was in fact guilty of voyeurism. Indeed, the entire court agreed on this point. And in reaching that conclusion, and I'll just focus on the majority's opinion for a moment, what the majority did was reject that location-centric interpretation of the phrase, circumstances giving rise to a reasonable expectation of privacy that had been advanced by the defendant. Majority rejects that view and instead applies a much more contextualized approach. Without getting too deeply engaged in the list of factors that the majority regards as significant when determining whether or not one is in circumstances that give rise to a reasonable expectation of privacy, it's worth just quickly scrolling through that list. And I'm looking right now at paragraph 29 of the decision in Jarvis. And I would just first observe that this list, lengthy as it is regarded by the majority as non-exhaustive, which means that in subsequent cases, other courts may well conclude that factors that are not included in this list may be also germane to the question. And furthermore, the majority is also clear that not all of these factors need to be present in any given case. It may be enough for some factors to exist, but not others. And moreover, the majority is not, transparent about how much weight these various factors should respectively receive vis-a-vis each other. So just at the outset, let's point that out, that what we don't have here is a nice, elegant checklist, and all we need to do in each subsequent case concerning voyeurism is just tick the boxes and we'll know. There's a very real question of balancing, and what's more, a sort of, dare I say it, ex post facto element to the analysis, where the judge will only be able to decide after having seen what the allegations are against this or that defendant. Only then will the judge determine, okay, which of these factors are germane to my analysis here. So with that, let's go through some of these factors. First, the location the person was in when she was observed or recorded. So here, the majority is essentially saying to the defendant, look, we agree with you that location matters. We just don't agree that it is in itself dispositive or even particularly weighty. But it matters. Second, the nature of the impugned conduct, that is, whether it consisted of observation or recording. So the majority is suggesting that one may have, depending on the circumstances, a reasonable expectation of privacy with respect to being recorded, even if they wouldn't necessarily have a reasonable expectation of privacy with respect to being observed. Awareness of or consent to potential observation or recording. So the majority suggesting that, look, if the complainant had was aware that they were being observed or recorded, that might make a difference to the reasonable expectation of privacy they had, or the reasonableness of the expectation of privacy they had. Number 4, the manner in which the observation or recording was done. So what sorts of technology was being used here that the complainant might reasonably expect to have been used. The subject matter or content of the observation or recording. What's this person doing? Any rules, regulations, or policies that governed the observation or recording in question. This too could matter when we're talking about institutionalized environments or regulated environments. That can inform, says the majority, what expectations of privacy are reasonable under the circumstances. The relationship between the person who was observed or recorded and the person who did the observing or recording. So the relationship between, essentially, the complainant and the defendant. That may be significant in determining or in assessing the reasonableness of the observed party's expectation of privacy. The purpose for which the observation or recording was done. And finally, the personal attributes of the person who was observed or recorded. So this is, as I say, a lengthy laundry list of factors here. And again, keep in mind that in a given case, we may find only some of these factors present, and potentially there may be further considerations, because this list is non-exhaustive. There may be further factors that a judge can rightly bring to bear on the question of whether there was a reasonable expectation of privacy. The very fact that this list is non-exhaustive, that it involves balancing a range of considerations, that only some of these considerations may be germane in a given case, all of this leads to what we might think of as a quite, dare I say, wishy-washy sort of test for when we have circumstances that give rise to a reasonable expectation of privacy. And in particular, it might raise concerns that in future cases, that judges and courts have a great deal of discretion in deciding, again, almost after the fact, whether or not this or that defendant falls within the four walls of Section 162 sub 1. And now I don't want to overstate this. Again, the very fact that the majority in Jarvis in paragraph 29 gives us this laundry list of factors, gives us a sense of what it is we are meant to look for, and arguably gives us a sense that what we can look for is quite broad. All of this is instructive and helpful to future actors. Because if nothing else, it gives you a heads up that whatever you do, don't assume that because you're in a public place, that means you can't be convicted of voyeurism. You can. And that's far from nothing. That doesn't give actors perfect certainty about what they can and can't do, but it gives them some degree of notice, albeit imperfect notice. And what's more, it does have some constraining effect on judges, such that they can't simply do whatever they want based on their own possibly unreflective moral intuitions. So I don't want to over-egg the pudding here. I don't want to suggest that we have no notice, that we have no certainty, that we have no constraints on judicial actors. None of that would be true. But is it the case that we have perhaps significant room for uncertainty, significant room for judicial discretion after the fact? Arguably, yes. And to the extent that we can say that, the gap between common law offenses and judge-made law interpreting statutory provisions closes. And that's the chief point that I want to raise here. And this is a point that the concurring judges in Jarvis hammer away at, because they're quite concerned about the majority's open-ended test. They worry that it seems to permit the courts to revise the meaning of voyeurism on an ongoing basis, and that this effectively licenses the courts to create what is, in everything but name, common law crimes, contrary to Section 9 of the Code and the decision in Frey versus Federick. And it's for this reason that the concurring judges would adopt a much more buttoned-down test, a test that involves consideration of somewhat fewer factors, giving somewhat greater weight to the extent to which the complainant had control over her environment. And the idea being that if we can button down this interpretation, if we can button down the list of factors to be considered in future cases, well, this will promote certainty, this will promote greater notice, and it diminishes further the separation of powers worries that we might otherwise have, that judges in future cases can, as it were, make it up as they go along. Earlier, I noted that Section 9 is not the only section of the Code to address the role of the common law in the criminal law. There is also Section 8 sub 3 of the Code, which, as we have seen, preserves the power of the courts to create or alter common law defenses. Now, I noted earlier why it is that, in principle, common law defenses are less problematic than common law offenses. To the extent that we are concerned about being, as it were, surprised by ex post facto decision-making in criminal cases, those concerns are less pronounced in the context of unexpected or surprise acquittals than unexpected or surprise convictions. And so considerations of certainty and fair notice simply have less traction when in the context of common law defenses. But there are also separation of powers based reasons for thinking that common law defenses at least often or can be less problematic. So to make sense of this point, we're going to need to take a quick moment, perhaps not quick enough, to distinguish between various kinds of defenses, just to see why they can give rise to different sorts of issues. And just a reminder too, that remember why it is that common law offenses are thought to raise profound separation of problems concerns. In declaring that a certain course of action is criminal, one is engaging in a profound act of social policy making. As I said earlier, in a stroke, one takes an activity or a practice or a course of action that may be regarded as benign or harmless or even laudable, and suddenly sweeps it away, says, no, you cannot do that anymore. Or alternatively, if there had hitherto been no requirement on you to do something, and the criminal law says, now you must do it, that too can have a profound effect on activities, practices, relationships. So it is precisely because the creation of criminal offenses can have such a dire impact, such a profound impact on social activities, practices, relationships, institutions, that intuitively we think that the body which should create criminal offenses is Parliament. That your elected representatives, if anyone is to make a criminal offense, it should be them, because they are accountable to you. On the other hand, unelected judges, precisely by virtue of not being elected, lack that accountability in any sort of comparable sense. And we get rather nervous about the idea of unelected judges whose intuitions about morality and public policy may not square with the wider public. We get nervous about the idea of judges creating criminal offenses or expanding criminal offenses at common law. So what kinds of defenses are there? And why might the type of defense we're talking about at any given time, why might that make a difference to the appropriateness of creating or altering common law, altering defenses at common law? Well, the first type of defense that we often refer to is excusatory. These are defenses, as we'll see when we move much later into the term, defenses like necessity and duress. And we don't need to get really deep into the weeds on those particular kinds of defenses, nor do we need to delve deeply into the criminal law theory of excuses. For our purposes, it's enough to observe for now that when we're talking about excusatory defenses, we are not acquitting the defendant on the basis that he or she has done nothing wrong. Quite the contrary, an excuse presupposes that the defendant has engaged in wrongdoing. Where an excusatory defense is in play, we acquit the defendant because we think that in an important sense, he or she could not have acted otherwise. And that to that extent, the defendant lacks culpability, or at least is an inappropriate object for punishment. Another category of quote-unquote defenses are institutional defenses. And these are defenses, and I'm using that term in a rather loose way, are defenses like entrapment or abuse of process. Now, where such defenses as these apply, they again operate not on the basis that the defendant has engaged in anything other than wrongdoing. Again, the presupposition is that the defendant engaged in wrongdoing. What we are doing is staying the proceedings on the basis that essentially the state lacks the standing to hold the defendant to account. Now, why would that be? Well, often, if this sort of institutional defense is in play, it's because the state may be, for example, implicated in the very criminal act for which the defendant has been charged. And under those circumstances, again, we have an intuition that it simply is not appropriate for the state, the same body that, as it were, is implicated in the offense, to at the same time punish the defendant for engaging in that offense. So, but importantly here again, there's not a suggestion when one of these institutional defenses operates that the defendant is somehow blameless or that the defendant engaged in anything other than wrongdoing. Now, justificatory defenses are an entirely different matter. These are distinct from both excuses and institutional defenses, because whereas excuses and institutional defenses operate in spite of the fact that the defendant engaged in wrongdoing, justifications deny that the defendant engaged in wrongdoing at all. Essentially, if a justificatory defense is in play, one claims that although the conduct is ordinarily wrongful, because the defendant, because Parliament made it an offense to engage in this sort of conduct, there is some additional factor which all things considered renders this defendant's conduct permissible. Now, importantly, justifications take Parliament's judgment, general judgment that this sort of conduct, whatever it is criminally wrongful, and essentially qualifies it to some extent. The mere fact that justification-based defenses qualifies the circumstances under which engaging in a certain course of action is criminal, the mere fact that it does that isn't problematic in and of itself. It's not a problem, for example, that the criminal code sets out circumstances under which one can apply force, even lethal force, in self-defense. Parliament made it a criminal wrong to kill, and Parliament can qualify that judgment by saying that, notwithstanding the ordinary prohibition on the application of force, it is permissible for someone to use lethal force in one's own defense. Now, what makes that unproblematic is precisely the fact that it's Parliament that made that decision. We would have a very serious problem if the courts were able to do this, because they are now deciding for the rest of us that conduct which Parliament, which your elected representatives decided was criminally wrongful, is now acceptable. And it's for precisely this reason, the sense that creating justification-based defenses can be as profound an exercise of social policy making as the creation of offenses, that the Supreme Court has consistently treated justificatory defenses as matters for Parliament and not for the courts. Further, the Supreme Court has rejected the idea that if Parliament makes it an offense to do X under circumstance Y, that the courts can then turn around and treat, say, circumstance Y as an exculpatory factor. To do this, to recognize the power of courts to do such a thing, would effectively mean that the courts could remake social policy contrary to the wishes of your elected representatives. And what's more, in the absence of a direct constitutional challenge to the statute itself. If you want to say that there's something wrong with a criminal offense, something that makes it constitutionally unacceptable, then you have to make a constitutional challenge. And that's the end of it. What the courts cannot do is use their Section 8 sub 3 powers to effectively rewrite criminal statutes in the absence of a constitutional challenge. Now, of course, this separation of powers concern also ties into certainty and fair notice concerns. Because, of course, if the courts could simply rewrite elements of criminal offenses, could treat a circumstance that Parliament regarded as inculpatory and now change that into something exculpatory, or create circumstances under which that circumstance is exculpatory, what this would effectively do is throw into grave confusion for all of us what counts as a crime and what doesn't. So these problems of separation of powers are closely related to the problems of certainty and fair notice. In the end, it's important for all of us to know, as it were, where the buck stops. Who can make criminal offenses and who can't? Now, one might argue that I've proven too much here with this whole discussion of justification-based defenses. If it's inappropriate for courts to engage in this sort of social policy making, then why wouldn't it be just as inappropriate to recognize excuses or institutional defenses? And if we say that recognizing or expanding or altering all of these defenses is inappropriate at common law, well then, what work does Section 8 sub 3 do? And the answer to that question is, but not all defenses operate the same way, as we've seen. It's inappropriate to recognize justification-based defenses at common law because these sorts of defenses deny the wrongfulness of the defendant's conduct. They take what was otherwise criminal conduct and makes it permissible. But excuses and institutional defenses don't do that. Recall that those sorts of defenses operate in spite of the fact that the defendant's conduct is nonetheless wrongful. When these defenses operate, it's either because the court has concluded that the defendant really could not do otherwise, or on the basis that the state is somehow implicated, we'll say in the paradigm example of paradigm instance of institutional defenses, that the state somehow implicated in the criminal wrongdoing in question. Now, because these defenses operate in spite of the fact that the defendant acted wrongfully, what recognition of these defenses does not do is take wrongful conduct and make it permissible. These defenses recognize that, as it were, the normative universe hasn't changed. What was criminal continues to be criminal. All we're doing when we allow these excusatory and institutional defenses to operate is say, in this instance, we think it's inappropriate to punish you, this particular defendant. But we're not changing what's impermissible and what's permissible, what's wrongful and what's acceptable. We're not altering the boundaries of those things in principle. And for that reason, it is thought relatively unproblematic for the courts to create or alter the boundaries of excusatory and institutional defenses, whereas doing that in the context of justificatory defenses would be deeply troubling. There is one conspicuous example of the Supreme Court of Canada using its powers under Section 8 sub 3 to effectively rewrite a criminal offense, and in the process raising the very concerns that informed the creation of Section 9 of the Code. And that case is the Queen versus Joe Bidun. Joe Bidun is a strange case because, in a way, what the court was simply purporting to do was interpret Section 265 of the Criminal Code, which sets out the definition of assault. So in particular, what the court is looking at is Section 265 sub 1 sub A. And that defines the offense of assault and states, a person commits an assault when, without the consent of another person, he applies force intentionally to that other person, directly or indirectly. And the central issue in Joe Bidun is, in a sense, the meaning of that phrase, without the consent of another person. Now, observe that Parliament expressly averred to without the consent of the other person and suggested that its absence must be proven, that the absence of consent must be proven in order to convict someone of assault. Quite simply, Parliament indicated in clear language that one cannot be guilty of assault where the complainant consented to the application of force in question. And yet, the majority in Jobidon took the view that it was open to the courts to decide on a case-by-case basis whether the complainant's consent was legally valid or operative, based on the court's own view of the social value of the activity or practice in which the defendant and complainant were engaged at the time. So, going forward, one couldn't just rely on the apparent consent of the person with whom one was engaging in physical contact, because it might be that if the matter ever went to trial, the judge could decide that the touching in question, whatever it was socially valueless, and that the consent apparently given by the complainant was therefore legally inoperative. Plainly, this raises issues of certainty, fair notice, and the separation of powers, since the code provision itself makes clear that consensual conduct cannot be assault. So how did we get here? In taking this position, in adopting this approach, according to which the courts could decide on a case-by-case basis whether or not a given activity or practice has social value, and on that basis decide whether it would be possible for this complainant or future complainants to give legally operative consent to it. What the majority was doing was claiming common law authority. But how? Wouldn't claiming common law authority to expand and rewrite the offense of assault push up against Section 9 of the Code, and indeed the Supreme Court's decision in Frey and Frederick? The answer is it would. But the court claimed that it wasn't exercising common law authority over offenses. The court claimed that it was exercising its common law authority over defenses, as conferred by Section 8 sub 3. Consent, the majority claimed, works as a defense at common law, and so it had the power, the court had the power, to circumscribe its ambit. Put another way, the majority wasn't purporting to widen an offense. It was purporting to narrow a defense. But wait a minute. The effect is the same. And this underscores the fact that, used incorrectly, the authority conferred by Section 8 sub 3 can raise the very same concerns as those which animated the creation of Section 9 in the first place. And it is widely agreed that this aspect of Jobidon, and we will return to Jobidon in future lectures, but it's widely agreed that this aspect of Jobidon, in which the court asserts in the name of Section 8 sub 3 this power to recognize on a case-by-case basis the inoperability, the legal inoperability of consent, that this aspect of Jobidon is wrongly decided. First and foremost, it's contrary to the clear language of Section 265. But it's also contrary to a broader reluctance of the courts to create justification-based defenses at common law, and to recognize defenses that essentially negate express offense elements. Indeed, one could take the view that this aspect of Jobidon is in tension with the express language of all things, Section 8 sub 3. Here again is Section 8 sub 3 of the Code. Over here, and it states, again, every rule and principle of the common law that renders any circumstance a justification or excuse for an act or a defense to a charge continues in force and applies in respective proceedings for an offense under this act or any other act of Parliament, except insofar as they are altered by or are inconsistent with this act or any other act of Parliament. And of course, what does Joe be done do? Joe be done operates in the face of the express language in section 265, making it an element of the offense of assault that one have acted without the consent of the recipient of the touching or application of force. And of course, that final clause in section 8 sub 3 is quite significant, right? It's not a throwaway line. It's precisely that clause which allows section 8 sub 3 to sit comfortably alongside section 9. It's no good saying in one and the same breath that only Parliament can create criminal offenses, and that, but the courts can alter effectively all of the elements of those offenses simply by saying, oh no, these are not offense elements, but defense elements. The two provisions, section 8 sub 3 and section 9, are able to coexist because of the recognition in section 8 sub 3 that ultimately Parliament has the last word. So this aspect of Joe be done is almost certainly wrong, and its reasoning has not been widely endorsed elsewhere. Indeed, there are very few cases in which appellate courts have taken up the Supreme Court's invitation to declare that consent to certain activities is legally invalid after the fact on social policy grounds. Now we have to be a little careful here, because it's not the case that it's never been used. There are a couple of cases out there, and not insignificant cases, which we'll discuss in subsequent classes. But they are rare. Only recently, the Supreme Court had an opportunity to overrule this aspect of Joe be done in a case called Barton. The Supreme Court decided not to say anything about this one way or the other. But make no mistake, Joe be done is a clear outlier, reflecting an awareness that, again, used improperly, the authority conferred by section 8 sub 3 can raise serious problems of certainty, fair notice, and the separation of powers. Okay, well, that brings us to the end of this first video. And in the weeks that follow, we'll do a little bit more work on sort of foundational concepts, particularly work on the constitutional scaffolding surrounding the criminal law, and a fair amount of work on statutory interpretation before we move on to ideas of actus reus, mens rea, and indeed the whole idea of an offense element. I expect that most of the videos that follow won't quite be as long as this one, and with luck won't quite be as abstract. It is ironic that right at the front end, we have to deal with some of the more abstract ideas that we'll deal with in the entire course, and that's simply because we're talking about the criminal law at a much higher level of abstraction. As we get our mitts into specific criminal offenses a bit more, you'll see that it's not quite as abstract as all that. But for now, thank you for hanging in there, and see you next time.